Default judgment happens when a defendant fails to file a defence or a notice of intention to defend in time. The plaintiff can apply for a judgment without opposition. But it is not automatic. Courts still must ensure the claim is proper. In Queensland, this is controlled by Rule 288 of the Uniform Civil Procedure Rules. This rule allows a court, when a defendant is in default, to give judgment justified on the pleadings, even if relief wasn't specifically claimed. Still, the court must check that the pleadings are valid, jurisdiction is correct, and the relief is appropriate. When a defendant defaults, factual allegations in the plaintiff's statement of claim are taken to be admitted. But that doesn't mean everything is accepted. The courts must first determine whether the pleaded defamatory meanings or imputations are legally capable of arising from the publication. That's a question of law. Only if the court accepts that meaning can it treat it as admitted and move on to assessing damages. Even in default, the court must ensure damage are proportionate to the harm under Section 34 of the Defamation Act. Malice is generally disregarded unless it affects the harm under Section 36. But apologies, corrections, or offers to make amends can mitigate damages as per Section 38. Also, beyond damages, court may grant injunctions, order interest on damages, and impose costs, including indemnity costs in blameworthy cases. If you're a plaintiff, your focus must be plead clearly, gather evidence of harm, and address remedies. If you're a defendant, don't ignore the claim. File a defence or notice of intention to defend immediately, or you risk losing any chance to contest the facts, meanings, or defences. Default judgment in defamation are powerful, but they're no free ride. Courts retain safeguards. Only legally possible meanings get enforced. Damages must be rational and evidence-based, and remedies beyond money may follow.